With that, I would ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the 11 o'clock docket.
Thank you, Your Honor. May it please the court. The 11 a.m. docket, Friday, November 3rd, 2023, consists of one case, appeal number 123-216, State of Kansas versus Zachary McFall. Brief both sides. Counsel has requested 3 minutes before rebuttal. Counsel will approach and enter their appearance.
May it please the court, Zachary McFall appears through his attorney, Jennifer Roth, from the Appellate Defender Office, present and ready for argument.
May it please the court, the state appears by Deputy District Attorney Jody Litfin, present and ready for argument.
Okay. Thank you, counsel. Ms. Roth?
May it please the court, my name is Jennifer Roth, and as I said, I'm from the Appellate Defender Office. It's my honor to be here in this new courtroom representing Zachary McFall. Chief Justice Lukert, I would like to again reserve 3 minutes for rebuttal.
3 minutes is reserved. Thank you.
By way of an overview, this was a trial that started days after the governor and president of the United States declared state and national emergencies. A jury convicted then 17-year-old Zachary McFall of premeditated first-degree murder, first-degree felony murder, and criminal discharge of a firearm. But that trial should not have happened at that time with that defense attorney. 25 days before the trial date, Zachary's attorney successfully argued for a competency evaluation based on concerns he had about Zachary's young age and ongoing history of mental health issues. However, 10 days later, 2 weeks before the jury trial started, the same attorney abandoned those concerns and instead spent time defending himself against a comment made in a competency exam, as well as zealously advocating against Zachary's motion for a new attorney and revealing confidential communications while doing so. As for the district court, its initial reaction to this incarcerated teenage boy's letter requesting a new attorney was, it really helps if you double space it. When the court denied Zachary's request for a new attorney after cross-examining him, the court failed to make the legally required inquiry and relied on errors of fact. From that point on, Zachary didn't stand a chance. His attorney had already thrown him under the bus, a move endorsed by the trial court in its ruling. So what happened at trial and sentencing may be shocking, but it is not surprising. And speaking of trial, the state's closing argument, which went unchallenged by Zachary's attorney, misstated the law, and there were inapplicable jury instructions the state insisted on that were confusing to the jury and did not tell them what they needed to know to render reliable verdicts. And because this trial should not have happened with this defense counsel, I begin with issue number 1. The state does a good job, arguably better than me in some ways, of setting out the law, the relevant law on this issue. The right to conflict-free counsel is grounded in the 6th Amendment, and the court has an independent duty to inquire when it becomes aware or should have been aware of a potential conflict. As the state says in its brief, the focus is not on the defendant's relationship with the attorney, but on whether the attorney can adequately represent the defendant's interests. This record shows what the district court failed to see. This attorney could not adequately represent Zachary's interest, even without the benefit of hindsight. The record that we have as of March 6, 10 days before Zachary's trial, includes the following: that the attorney on February 20th went on and on about concerns with Zachary's age and went so far as to request and receive a competency hearing. On that day, Zachary also talked to the court, but everybody's pushed pause and said, we got to get your competency determined first. Zachary was that same person a mere 15 days later, but his attorney said nothing about those same concerns. And there's nothing in the record that shows that something happened between February 20th and March 6th that wiped away all of these concerns.
What are we supposed to do with that, though? The finding of competency has not been challenged, just the fact that substitute counsel was not given.
Right.
So what do we do with that?
Right. So if the inquiry is, well, first of all, I feel like I've laid out in our briefing many bullet points as to how Zachary had justifiable satisfaction. But I thought about today sort of more tailoring my comments to, as the state puts it, well, where's the proof that where's the evidence that the attorney couldn't adequately represent Zachary, and thus the court should have given him a new attorney? And to that, I agree, the competency is over here. But the fact is that on the day when they do talk about what Zachary's problems are on March 6th, that at that time, the attorney zealously argues against his client and his client's concern, answering questions the court hasn't even asked him about, I don't think I have a conflict. And so I know I've talked about competency, but the inquiry is, could he represent this child? And the answer is the record is replete with evidence that he could not, and that the court erred in not seeing that, in not making the proper inquiry.
But the court did inquire, and Zachary McFall had 2 items that he told the judge that he was worried about. The first related directly to a conflict because he thought it was a conflict that his attorney had represented a witness in his cousin's murder case. And they talked about that. But then the second one was that he'd only been there a few times to visit him, and that he didn't have discovery.
Right.
So then they talked about that. And the judge inquired and then asked him an open-ended question. Was there anything else? And he said, no. So what do you think the judge should have asked that he didn't ask that was necessary to ask?
Certainly. Before I do that, when you mentioned the thing about the discovery, the court actually made a finding that the attorney had given Zachary the discovery, even though minutes before the attorney admitted he'd never given Zachary the discovery.
Well, he
But to
admitted
your
he
point-
hadn't given him the police reports, but they talked about often they don't do that because then they're disseminated. And so he said, well, they talked about whether he got the information from discovery.
Right. And here we have let me answer your original question before I get sidetracked again. So what do I think the court should have asked? Well, number one, I think that the court should have asked the attorney about the concerns he had 15 days before that. Never asked him about that. And some of those same concerns were in Dr. Blakely's report. Now, I get that this is a competency report, but the law says that the judge is supposed to, use information to ask right questions. Like literally the competency report is on the bench and has some even more concerns beyond what his attorney mentioned 10 days before. So judge didn't ask the lawyer, didn't ask Zachary, didn't ask.
But since they've gone through all of that, isn't there gone through all of the competency? They had this separate competency hearing. So my concern is
This was the competency hearing. You're right. They're the same time. You're right.
well, there was a ruling on competency first. So doesn't the judge have to approach the second hearing with a presumption that McFall is competent?
Oh, I'm not arguing he's not competent. And that, you're right. Nobody raises that anyway. I'm not arguing he's not competent.
Okay.
I'm arguing that this attorney could not represent him. And that when you asked me, what do I think the court should have asked him? Okay, let's pretend that Dr. Blakely's report doesn't exist. The court still was made aware 10 days before or 2 weeks prior about all these concerns that his lawyer had about, was he tracking? Could he understand his mental health history that literally started
How
when he
is
was
that a
5?
conflict of interest?
Because the question is, can you represent this child? The question is, can you represent this client?
Well,
And all the
it seems like you're
indications.
arguing that no one could represent this child because he has so many suspicions.
As
So
a person,
let me just, I want to take a step back because
Okay.
we're really, really getting into the weeds,
Mhm.
okay? So when presented with a potential conflict, the district court can err in 3 ways. by failing to conduct an inquiry, and that's not what you're saying. The judge did conduct an inquiry, right?
Okay, sure,
Okay.
because I'm going to go with the second factor, but go ahead.
Right, by failing to conduct an appropriate inquiry, which is what you're saying.
Yes.
So what is an appropriate inquiry under Kansas case law? Requires two things. Number one, you have to inquire into defendant's dissatisfaction with counsel. And that's what Justice Wilson is saying.
Mhm.
Okay, so under our case law, and that's when he said there's a conflict because of this Mandy, the material witness, and didn't give me discovery. And then the second thing is once the trial court judge under our case law figures out what the dissatisfaction is, an appropriate inquiry requires inquiring into the facts necessary for determining if that dissatisfaction warrants new counsel. So they reviewed the whole thing about the Mandy, and they figured out actually that he represented the material witness who was testifying in favor of this, on behalf of the state against the person that killed his cousin. So there was no conflict there. Would you agree with that?
That there's no conflict there?
Yeah.
No,
Why not?
because, and I think this is part of where Zachary's youth comes in, like, these are.
No, I'm talking about the conflict in representing Mandy.
Right. Do I think that that's ethically a conflict? No.
Okay.
Do I think it is a conflict for a 17-year-old boy? And that woman did not testify for this. She was a material witness forced to come there and testify for the state in a case that involved his cousin getting killed. And so do I think that is ethically a conflict? No. Do I think that I can totally understand how a 17-year-old boy in that situation would find that to be just justifiable dissatisfaction? Yes.
Okay. And the court ruled, but here we're not talking about whether the court was right. You're challenging, because that's under subsection C. That's, then you're talking about whether the decision about whether to appoint substitute counsel. We're just talking about the investigation, the appropriate inquiry.
Okay.
Okay. So the judge did inquire into this, right?
Okay. That's fair. Yes.
Okay. And then the failure to communicate regarding the discovery, and the judge inquired into that, and the judge determined, and I know that there's some, there were issues there, but that perhaps, probably that he didn't get the written discovery in writing form,
Right.
but he was informed
Right.
of what the discovery was. Would you agree with that? That he inquired into that? We're not talking about whether he was right or
Yeah,
wrong.
you're right. I realize basically my issues with the third thing we haven't
Okay.
even got to.
Thank you.
Sorry, if I just chilled for a minute. You're right. It's true that the judge asked him about those two things.
Okay.
And so I suppose when it comes down to it, the thing that makes this the problem is that the court reached an unreasonable result after that inquiry. I still argue whether it's appropriate, but whatever. Let's just skip to that last part.
Okay.
And our contention is that the court reached an unreasonable result. And part of that, let's just say let's just even take the Mandy thing out of it. Let's just go with the discovery part. Minutes before, Zachary's attorney straight up told the court, I haven't given him that discovery yet. And yet the court makes a
Written
rule.
discovery.
Right. That's true. And the court, before this time, there had been a waiver hearing that had one detective testify. That was it. I don't even think there weren't any exhibits at that one that were even admitted later. And then you had a preliminary, I'm talking about what Zachary had seen. Like why, oh, sorry, right.
I didn't know what waiver you were talking about.
Yeah. And then he had a preliminary hearing that had 6 lay witnesses and three exhibits. I guess I'm thinking about an argument.
But were any of those arguments of conflict of interest? I mean, that kind of goes to ineffective assistance of counsel, right? Not conflict of interest.
If part of the inquiry is, can you adequately represent this person?
Well, but there are different ways about So justifiable dissatisfaction, or whether you can adequately represent people under our case law, three things: conflict of interest, irreconcilable disagreement, or a complete breakdown in communication. And then you have a whole separate thing of, ineffective assistance of
Right.
counsel.
And I-
But, and he did conflict of interest.
I think that, but you just said those are three ways you can have a conflict?
No, three ways of justifiable dissatisfaction, which is.
Right.
another
And so, right. So he's arguing, if the argument is he has just, right. So, so you're saying I can't argue that.
Well, it's not how it was framed to the district court, and you're asking us to find error in the district court's decision. And if the district court wasn't presented with all of these
No.
things about what are basically ineffective assistance of
Of-
counsel, I don't see how we can find the court erred.
Of course, they weren't presented because his lawyer was too busy arguing that there was no conflict, revealing confidential communications in the process, and answering questions the court hadn't even posed. He was too busy throwing his client under the bus to raise these things. And so then we may say that a 17-year-old boy has to say the right legal words. I mean, the thing is that at the end of the day, the court did not, it had evidence in front of it from earlier from the lawyer, from Zachary, and from the only expert we have in this case, Dr. Blakely. And the court did not make a sufficient inquiry into those things and did not reach a reasonable result in light of what was in front of it. The thing that's hard here is that I have represented 8 teenagers charged with murder, and so it is tricky to be like, well, at any rate, at the end of the day, it is our contention that the court did not follow the law in light of everything that was in front of it.
Yeah, and you're close to running out of time, Ms. Roth, but I would like to move you to the second issue and the failure to advocate during the proceeding. And what struck me in this case, you have a long history with criminal law. I know many of us up here do too. And I don't think I've ever seen a statement, and I'm just going to read it so these students can hear it too. Notwithstanding all, and this is a statement to the court as he's representing his client at sentencing. Notwithstanding all that, Judge, I'm at a loss in good faith to present something positive that I can say about my client. Throughout the course of this proceeding, he's exhibited no remorse, no repentance, no acceptance of the criminal action, no acknowledgement of the life that in fact was taken. Although he was not the shooter, the criminal action he was involved with was overwhelming, and it goes on. Is there anything that can I guess the point of chronic is that, yeah, he did say some things about a concurrent sentence as opposed to a consecutive sentence. Is there anything that can overcome this kind of statement and maybe illustrates what you're talking about, but it's this post motion to withdraw? I was sometimes things jump out to you as you read cases. This especially jumped out. And what do we do with that?
Well, I don't see how you can overcome it. And on top of, as if that wasn't bad enough, there was no option for the court to give Zachary anything but the hard 50 because his lawyer didn't file any kind of a sentencing motion. And so as if that wasn't, as if walking in completely, unprepared, wasn't bad enough, then to say that, I've never seen anything like it. I can, you're right. I've appeared in the courtrooms with these folks, and I've never seen anything like it.
Okay, so I also was, that also struck me. But I also, under chronic, which I didn't really realize this until I reread it, but if you are counsel and you don't say anything, then you're also, then it's automatic prejudice under chronic. So you have to say something, right? Is that, or am I misreading chronic? And then what do you say in a situation like this? I mean, I know you maybe shouldn't say what you said, but I mean, you can't stand silent under chronic, is that right? Or am I misreading it?
Then maybe he should have filed his own motion to withdraw from representing this child.
But what would you have said? What would you have said for sentencing?
Okay,
At sentencing?
first of all, I would have gotten some sort of I would have gotten some sort of workup of this child. I would have probably found a way to trot in that stack of records that his attorney had on February 20th and March 6th and before that. And I would have gotten an expert and I would have brought people on planes to talk about how children are children. That is what I would have done. And it sure wouldn't have walked in there with no motion on file and said those things. He could not represent that child on March 6th, and we see that later.
Ms. Roth, I have great respect for you and your abilities, but we have what we have. And the chronic case appears to me to address complete abandonment at that with that standard. This isn't an ineffective assistance of counsel claim. This is a chronic claim. And chronic says that you have a Sixth Amendment right to counsel and you cannot completely abandon your client. Given the fact that counsel argued for concurrent sentences and also corrected the state's assertion that there should be a sentence for both the premeditated first-degree murder and the first-degree felony murder, and said, no, Judge, you can only do one. Given that he did those two things, and I don't think there's any contest or argument about that, can we find that to be complete abandonment despite everything else he said?
I see what you're saying, and I guess the one thing I'd correct is that he did not volunteer that thing up. It's the court. It was the judge who said that.
Yes, that's
And then his
correct.
lawyer said, "Oh, that's right, Judge." But he
Yes,
did argue for concurrent
right.
sentences.
Did agree with the judge.
And so you're right. He did argue for concurrent sentences. And so I guess if I could try and get over the comments, I guess what I would say is, I think the abandonment was complete when you walk into a 17-year-old's sentencing where the presumptive sentence is the hard 50 and you have filed no motion for a departure, which the statute permits you to do, that you actually abandoned that child before you even stepped in the courtroom and said the things that you did. And so that would be my contention. There was no choice. You could have said the most glowing things ever about Zachary walking in there. But if you walk in there with no motion to depart to the hard 25, in my opinion, you have already abandoned your client.
You're saying that motion is an obligation in every case.
Yeah, I mean, I would. I mean, I think are you going to always have the same sort of arguments and that sort of thing? No. But I can't imagine going in to sentence somebody for the hard 50 and not file a motion to try and at least get them the hard 25.
And that's the presumptive sentence.
The
So
hard 50 is the presumptive sentence. So again, you can go in, let's pretend that he hadn't said any of that stuff. Let's pretend he'd gone on for hours about how Zachary's a child and blah, blah, blah. There was no choice but for the court to give that child a life sentence with no possibility of parole till he was 66. So you have abandoned that child the minute you walk in without a sentencing motion.
do we have to ignore the concurrent, because there was the firearm charge. Do we have to ignore then the argument for the concurrent sentence? I mean, is that still chronic? Because you don't have to do that.
I mean, it is up to you all to decide, but what my
Chronic's
contention is.
Chronic's a U.S. Supreme Court case.
No,
so-
but it is you all, I am just arguing that the evidence of total abandonment, even if we take out what he said, that it is my contention that the total abandonment occurred even before that. When you walk into this sentencing, and there is no chance, you've not presented the court any opportunity to give your client anything but the hard 50.
Isn't there a requirement of factual basis for such a motion?
Yes,
And so
he's,
that would strike me as suggesting it's not a bright line rule.
Right. I was gonna say, once you said that, I was like, okay, maybe, I mean, I'd still probably find a way to do it, because that's how I would roll. But to your point, in this instance, and as I stand here, I can't remember all of the factors, I'm ashamed to say. But what you had here is first of all, he's a 17-year-old who Chris Kobach would argue doesn't have the cognitive ability to vote, but you have a 17-year-old. So there's an age as a departure factor. And because he was 17 or he's 16 at the time. And you also have as a departure factor, his mental health history. And so I believe in this case, there are grounds to make that, but you're right. Maybe I should stop short of saying that there's some sort of bright line rule, especially applied to other people that aren't me.
I mean, my problem, you've explicitly took the Strickland ineffective assistance of counsel stuff off the table. You did that.
I did that.
And then I get to the sentencing and the state wanted consecutive sentences. And this defense counsel said, no, don't do that. Make them concurrent. And the defendant got concurrent sentences over the state's objection. That does not seem like abandonment of counsel.
And at the end of the day, what I really believe should happen here is that this whole thing gets reversed. It should not have happened in the first place. We shouldn't even be having to talk about what happened at sentencing because this should have never happened with that attorney at that time. So if this court decides that he's not entitled to a new sentence, I mean, honestly, my biggest request, obviously, is that these get reversed and that he could be represented by somebody who doesn't have a conflict. And so, and if you all decide that that's not chronic, I guess we'll be arguing about it another day, and that's fine. But to me, that is not even the first request I'm making of this court. I believe that we have presented legal reasons why this whole thing should get reversed, which is why I was actually going to talk about issues 3 through 5 instead of 2. But at any rate, I know I'm well out of time. So if nobody has any other questions right now, I'll sit down for now.
All right, thank you. Ms. Litfin?
Thank you, Your Honor. May it please the court. The state appears by Deputy District Attorney Jody Litfin. I guess I will go ahead and start with issue 2 since that's what we left off on. I have a lot of comments here, but let's narrow it down to, first of all, the state did make a preservation argument. So if we're going to get to the issue and get past the state's preservation argument, I do want to mention that this was not raised below. Generally, issues of ineffective assistance of counsel cannot be raised for the first time on appeal. So this court has the option, and we would encourage it to not invoke an exception to address this argument for the first time on appeal. But if it does, this is a rare exception. I would encourage this court to avoid hindsight and what appellate counsel would do. Again, I respect what different attorneys, they have differing ways to represent their clients at sentencing, but that's not our standard. That's not what we have to look at. So let's hone in, as your honors were doing, to the rare exception that is chronic. It is reserved for situations which counsel has entirely failed to function as the client's advocate. We don't have that here, and that's our position. The failure must be complete. He argued his youth, whether he didn't file a written motion for departure, he argued his youth. He argued that as a factor, and he argued against consecutive sentences.
Sorry, I turned this off in case what good is it to argue youth or any other factor when it's a presumptive sentence? It's like saying, you can't do anything about any of the arguments if you don't have a motion for departure.
That's true, but we're talking about chronic, which is a complete failure of representation.
Yeah, but
So
I'm
if
just
you're
talking
going to
about,
find,
right, but I'm talking about your argument about the youth, it's like two ships passing in the night. I mean, she's saying that if you didn't file a motion for departure, it doesn't matter what kind of argument you make.
I still think that goes to the consecutive sentences.
Oh, okay.
Your Honor, and you're not required, as Your Honor was saying, you're not required to file a motion for departure in every case. I certainly don't think that there's any authority to say that, and whether counsel would have done it in this case or not, again, that's not the standard that we're looking at. So when we're looking at whether counsel has entirely failed to function as the client's advocate, the state is requesting that this court not find the chronic exception.
So it's
appropriate.
enough. And, I highlighted some of it in addition to what I said before. He said that counsel said, and as related to the court, usually in these cases, we have something positive we can say about our clients. And I'm at a loss to say anything positive about Mr. McFall. In fact, I'll relay it to the court, and the court knows this. He wrote a song while in custody about taking this young man's life. I mean, so we have this statement, and how is that how does that offset anything that counsel did in requesting a concurrent sentence? I just don't see, it seems to me, once you've said something like this or demonstrated such dislike and contempt for your client, how do you overcome that? I mean, how can you be an effective advocate? Doesn't that just equate to an abandonment of being an advocate?
No, the state would disagree, Your Honor, that it does not. It's not. And we're stuck with the record we are stuck with. I agree. You can read what he said. And if this court finds that that is a complete abandonment, I just don't think that that rises to the level where the court has found other chronic exceptions apply. For example, in a
I don't think any other exceptions that's applied had this kind of general just disregard, dislike, contempt for the person he's representing and who's getting a 50-year sentence.
And the state would disagree that that is a complete failure to represent your client. And I'll give the court an example.
Wait, what did you just say?
We would disagree that that is a complete failure to represent. No, sorry, Your Honor. And I did look up at least one example of, it's a little bit different of a case. It's a sexually violent predator case, but there I believe they found the chronic exception applied because during the proceedings in that case, defense counsel had stipulated to all of the evidence, even hearsay evidence, had done no oral argument, no written argument, nothing. So they found that was a complete failure to represent a client in that case. And we just don't have that here.
But specifically, are there any cases out there where the counsel is specifically or affirmatively might be a better word, advocating against your client? Now, most of the cases I found in preparing for today had to do with a violation of a plea agreement where, the state agrees to something and then they go in and, it's a contractual dispute because, they agreed in the plea agreement that they wouldn't oppose something. But do you know of any cases where, that's completely different than this case where, you have a counsel that is just affirmatively advocating against his client?
Do I know of any cases where that's
been an issue?
I didn't. I don't think that I cited to anything in my brief, and I don't think I can think of one like that. But again, we would just disagree that he is affirmatively arguing against his client here.
Really?
And
based on what Justice Rosen read to you?
Yeah, we would disagree. He's being frank. I mean, if we look at the evidence in this case, it's overwhelming. It's overwhelming. So I don't think he's arguing against anything because, again, he argued his youth, he argued against consecutive sentences, and he received concurrent sentences. So how can you argue?
Counsel and I'm at sentencing and I say, well, Your Honor, I'm going to tell you this is the most. I've been representing criminal defendants for 30 years. This is the most gruesome murder I've ever seen. He slit the throat and then he cut off the head and he put the head and just describes in detail for 5 minutes how gruesome and horrible it was. And, I've just never seen anything like this. It disgusts me. I want to vomit, that's okay.
I mean, I think the court would know.
Those are just facts.
They are just facts. And I think the court would have heard all of those facts if there had been a jury trial in that situation. And I don't know that that's arguing effectively against your client at sentencing when you're just acknowledging the facts. And again, I want to really put it in perspective of chronic, complete failure, no counsel at all, or counsel's asleep, maybe. I don't know. I didn't look up too many other examples because it's such a rare exception that applies. And Strickland's off the table, as Your Honor said. So we would just argue that this is not a rare exception that falls under the chronic exception here.
Is it fair to characterize your argument as this could have been a misguided strategy to be frank with the judge in order to obtain what the lawyer may have mistakenly thought was his best outcome, which is concurrent sentences? I mean, it sounds like that's what you're saying.
If we were looking at it from a Strickland yeah, I mean.
Well, that's my point.
strategy.
It sounds like your argument is that you can be ineffective and still not have abandoned your client. And I know you're not conceding ineffectiveness, but that
Right.
does sound like what you're arguing.
Well, I guess I'm just trying to put it in the context of chronic, which I think has to be a complete failure. And here we didn't have a complete failure. So I wasn't thinking of it in terms of, was he deficient or was he, did he provide ineffective assistance?
And you're saying we don't have a complete failure because, look, he came up with an approach, and at least the approach paid off to the extent of a concurrent sentence.
Yeah.
Okay.
Okay, so two questions. Number one, just to clarify, who came up with the concurrent thing? Was it the lawyer or the judge?
And Your Honor, I didn't reread sentencing this morning. But
I believe opposing counsel said it was the lawyer that came up with that
Okay.
part of it, but not
the part about,
not the double sentence.
Okay,
yeah,
okay. And then
I'm
the other
sorry.
thing
Yes,
is
thank you.
chronic. Is there an argument to be made that chronic really is a Strickland argument? It's a subset of Strickland where you don't have to prove deficient performance. So are we really precluded from considering Strickland?
Your Honor, my understanding is, yes, it's different.
It's a subset. I mean, she cited it in her brief.
It's an exception to Strickland in that it presumes prejudice.
Right.
So, the deficiency was so bad, i.e. complete failure to represent someone,
Right.
that there is no prejudice. I mean, that you don't have to prove prejudice. So I guess, yes, we're saying that there was no complete failure. And you don't need to presume, I mean.
We don't need to
prejudice is
presume
presumed
prejudice, but so then we could go on to analyze prejudice. And, and take into account whether or not all these statements that you disagree are advocating against his client, and talk about whether the result would have been different. And really whether deficient
That,
performance included failure to file a motion for departure.
I'm not sure if I'm getting too confused on this, Your Honor. Just the way that I understand chronic is, it's an exception. And it applies when you are just denied the assistance of counsel and you presume prejudice. So if you're not denied the assistance of counsel, then we're done.
And if we find that this was a complete abandonment at the sentencing, what would the proper remedy be?
I think the remedy would be new sentencing with new counsel. I don't know that I wrote that in my brief, but I think that would be the remedy is a new sentencing hearing with.
As opposed to a reversal and a new trial.
Right. I don't believe that's the remedy, because the critical stage where he was denied counsel, what they're alleging is at sentencing only. So I would limit it to the critical stage that they're alleging.
Isn't that the very reason, like in cases subsequent to chronic, like Bell, the United States Supreme Court has chosen not to apply that chronic standard to the sentencing phase, but instead indicated that that's truly a Strickland standard should apply to chronic type claims that are asserted to the sentencing phase.
I didn't really address that, Your Honor. I guess that the way that the state looked at it was that it could apply to a critical stage of the proceeding, like sentencing. I didn't look at whether, this court or what other courts commonly do.
And would you also, just moving you on to one last final question that I had, would you agree that the district court didn't use the right pick instructions here?
I don't believe that. I think I argued that they did use the correct pick instructions here, because there were alternative theories. Okay, the state agrees that that first degree murder has the two alternative theories, premeditated and felony murder. But here, when they're not charged in one count, we believe that we don't have to use those pick instructions that were discussed by the court because there were two separate counts here. So we would agree that they were properly instructed, given the fact that premeditated first degree murder was in count 1 and felony murder was in count 2, and they weren't charged in the alternative in one count.
So you think that the lawfulness of the instructions depends upon how the state charges, whether the two theories are included in one count versus two counts?
I think that was the distinguishing thing that we made in saying that the State versus Dominguez case was different than here.
But the notes on the pick instructions, if you read them, wouldn't direct you to that same conclusion, would they?
I don't believe they talk about it in as terms of counts. I think they just say alternative, which could be clear, I think, in the way that I wrote things as far as alternatives as in terms of counts versus
Theories.
alternative theories. Yes.
I really thought as when you read the transcript in a very limited, it's just a couple sentences. The prosecutor said, first of all, the judge said, we need to do pick 54-130 and the attendant verdict instruction and verdict form. And the prosecutor said, no, those are alternative charges, not alternative theories for the same charge. And the judge goes, oh, okay. But in the notes on use, it says that you should use it. And it says it's for alternative theories. And I don't understand how, isn't it a distinction without a difference? Alternative charges are alternative theories. It doesn't matter whether they're in two separate charges. They're alternative theories. Why does it matter? You know, I mean, this is the correct instruction, and why should it turn on whether the prosecutor decides to put it in two different counts?
The state's position would be that because it is in two different counts, you're going to have elements for each of those crimes in two separate instructions. So you're not considering one count of first degree murder under two separate theories. And the way that, if I can grab that the pick instruction, I think they set it out as there's been evidence presented on two theories of proving the crime. And then they say instruction number 1, it sets out premeditated murder, or, instruction number blank. Instruction number blank, it sets out felony murder. But here we have two separate counts. So instruction number 10, I think here, lays out all of the elements of first degree murder as a separate count that the jury has to go through those elements and find. And then in instruction 13, maybe, the felony murder elements are laid out. So we don't find that this was appropriate because we don't have one count and then two separate theories. They have to actually find they have to go through each element for premeditated first degree murder in one count and separately felony murder in the other count. So I don't know how this is clearly erroneous when the jury was told both of them are first degree murder counts, because both of the instructions did say charged with murder in the first degree, premeditated murder, murder in the first degree while committing an inherently dangerous felony, etc. There was no question that they were both first degree murder counts. They were just in separate instructions where they went through each one and had to knock off all of or go through all of the elements.
Where did it say in there that in a general instruction? Oh, I guess I have the jury instructions, but that when they go through, they were supposed to.
Sorry, go ahead, Nora.
Were the elements for each theory correct?
I believe so, Your Honor. I don't think there's any challenge to what was actually written in the instructions as far as what elements.
They challenge mental culpability and whether or not that was sufficiently explained to the jury.
In the aiding and abetting instruction, Your Honor?
Right,
Yeah.
Yes.
That's a separate, I wasn't addressing that challenge. I think I was just addressing whether that pick instruction about.
Well, and perhaps I was distracted when you said they didn't challenge the instructions. except for this. So were the elements correct for each theory of first degree murder?
I believe so, Your Honor, yes. I think that they laid out, at least for premeditated intentional murder, you had to do it intentionally, done with premeditation, and then the honor about the date. And then for the felony murder, there was the aiding and abetting part, and then done while the crime was committed, while committing the crime of criminal discharge of a firearm. So I believe the elements were correct. I don't think there's any dispute that the elements are correct. It's just how the jury was instructed on them, whether it be with that pick instruction, talking about alternative theories, or we just got two separate counts here with two separate instructions.
Is the point of this instruction, and is it 54.13? Am I right? Sorry if you don't know that. Yeah, I think it is.
Yeah, right.
Is the point of that pick instruction simply to avoid multiplicitous convictions? Because that's what can happen if a jury gets two counts or even maybe two theories and they say guilty on both.
Which is what happened here. Yeah, yes.
Right.
You can't be sentenced on both of those.
So
but
that's
they
the
did-
point. Well, I guess I'll ask, is there any other point to that pick instruction?
No, I mean, no, I think just explaining that there's two separate theories, you can
So-
find on either.
If there is no other point to that particular pick, does it become sort of harmless as a matter of law if one of the two guilty verdicts is void, essentially? I mean, don't we reach the same end?
Yes,
That's my question.
yes. And I don't see how this is clear error in this situation where we have two instructions that say essentially, yeah, the same thing.
There are other questions. Would you like to wrap up?
Thank you, Your Honor. We would just ask that this court affirm the convictions in this case. Thank you.
To the extent that anybody still is wondering, I'm looking at the sentencing transcript. And when the state started asking for Zachary to be sentenced on both first degree murder counts, the court said, let me stop you. I don't think I can impose that because they're multiplicitous. And then the state argues, oh, I think that at any rate, in the end, the court says, do you want to be heard on that to Zachary's attorney, who says, just briefly, Judge, it's my understanding and I agree and concur with the court's position that the sentence for Mr. McFall would be multiplicitous. So to the extent that that is something that people were wondering. I just had a few things I wanted to respond to. First of all, there was a conversation about how Mr. McFall's Zachary's attorney was actively arguing against his position at his sentencing. And you all talked about that in some different ways. And that just brings me back to March 6th. We don't need the benefit of hindsight to see that on March 6th at the hearing where Zachary was asking for a new attorney, we could already see his attorney actively, affirmatively advocating against his client. And the law tells us that you have to walk a line when the judge is inquiring, and this man stomped on it. And so that is the whole key here. And we saw that affirmative advocating against his client as early as March 6th.
Counsel, I understand that your primary argument is that the conduct at the sentencing hearing essentially relates back or is evidence of the conflict that should have been discerned much earlier. That's, as I understand it, your primary argument. But if you just consider the conduct at the sentencing hearing under chronic, if we were to agree that that's an abandonment with presumed prejudice, what would the remedy be from your perspective?
I was operating under the assumption that he would get a new sentencing.
Okay, so you would agree with the state's answer to that question when I asked, that it would be
That-
remanded for a new sentencing with newly appointed counsel?
That is what I've been operating under. The second point I wanted to make is that you talked about the wrong jury instructions. I didn't get a chance to really talk about the state's closing argument, but you all did talk about how they just used the wrong pick and the judge didn't even challenge it. What this demonstrates is that all of this happened without any pushback, without any, what's that phrase? Testing of adversarial testing by somebody else. So when you go to consider our cumulative error argument about things that the state said in closing argument, the instructions that the court used, when you go to look at our cumulative error argument, keep in mind that all of these things were happening, the closing, what jury instructions you were all happening with no response at all from Zachary's attorney. And so that we think is very important to keep in mind when you're looking at these errors. And maybe they aren't clear singularly, but when you take these things together, that is cumulative error. The third thing I wanted to just mention is the state's insistence that the evidence in this case was overwhelming. Now, it's true that the state had 36 witnesses and almost 200 exhibits, but amount of evidence does not equal overwhelming evidence as to the elements that the state was required to prove to have Zachary convicted and sentenced to the hard 50. The evidence was not overwhelming of premeditated murder. The state was required to prove beyond a reasonable doubt that Zachary had the specific intent to kill that young man and that he did so with premeditation, which is more than the instantaneous intentional act of taking another's life. There was not overwhelming evidence of that. And that is what got Zachary the hard 50. And that is why the state was so anxious to argue for that in its closing and to talk about what aiding and abetting is in a way that misstated the law, because that's what gets you the top count. And there was not overwhelming evidence of that. The last thing that I would just say is that during the closing argument, the prosecutor was being very real with the jury, which honestly I sort of appreciate, and was talking to them about the hard task before them, because there sat a 17-year-old boy. And one of the things that the state said to the jury, they asked and answered their own question, which was, is it a travesty to find a 17-year-old guilty of murder? Yes. And I could not agree more. And I am asking this court to reverse all of these convictions. Thank you.
Thank you. Thank you to both counsel for your arguments this morning. We will take this case under advisement